President must look at as to, let's say I'm correct on my grounds. But that is why, Chair, so I don't know what you would do, but it does not nullify my grounds if they are good. We put number 2 there, Chair, out of, I think it's not mine, it's Mr. Zuma himself who puts that, because he says, I don't want to destroy this commission. Is there no way where this can be done and all of this? So we put number 2 purely out of his own sense of responsibility. And I think it solves that problem, Chair. We can work around how do we make sure that the close to R1 billion paid here for this is not for nothing. So I think, Chair, I don't know the answer about what you and the President would do if I'm good on my grounds. And I don't want to offer the solution. But I think if you look further in the reliefs we seek, you will see that we've not shut the door. The stalemate I spoke about is a stalemate that I can do for my client. And it's a stalemate, but we don't want to go there. And so I think, Chair, in crafting your order, even if we are right or even if we are wrong, I would still plead with you that craft it in a way that does not sink this commission. That's my answer.
Yes,
but legally, my recusal cannot be incompetent because you and the President don't know what to do if we are wrong and I'm right.
Well, you see, it might not be a question of me and the President, particularly in the context of this commission. Maybe the same issues would arise with another commission, but this particular one. Because remember that the remedial action of the public protector said that the commission which would investigate all of these issues must be chaired by a judge selected, I think said solely by the Chief Justice, obviously appointed by the President. Now, you said earlier on that you referred to the fact that maybe the commission should not have consisted of one member because of its importance. After I had been appointed, I applied my mind to that issue to say this is a very big commission. Should I request the President to appoint other members, maybe one, or preferably 2 members of the commission so that I'm not the only one? And when I considered whether to make such a recommendation or request, the problem that I foresaw was that if there were 2 members added, it could result into a situation where when the report is made, the member of the commission that had been selected in accordance with the remedial action of the public protector could be overruled by the members of the commission who had never been contemplated by the remedial action, and that could cause problems. And then, of course, there was the question, if you make it 2, there could also be challenges. And of course, there is the issue that we are not just dealing with what the remedial action of the public protector said. There is an order of court which reinforced that remedial action. So there is an order of court effectively which says, which said the President must appoint a judge selected by the Chief Justice. So if I were to, for argument's sake, say, I think Mr. Skakane has made out a very good case for recusal. I must recuse myself. That means that there is a vacuum? Or do I say, okay, what should happen? Should another judge be appointed to hear Mr. Zuma's evidence? And then the question is, how would that work? Because I am the one who has had other witnesses who may have implicated him. How does it happen now if another judge is going to hear his evidence responding to those witnesses who were heard by me? Will that judge have to rehear those? It becomes complex. And of course, the president, even the appointment of that judge, who must appoint that judge? Because if the president appoints, there might be a question whether that's proper, given that the remedial action didn't have that, or that's not proper. There may be all kinds of arguments. So there are those issues. And I think part of what you have been saying, you have said to me is that it may be that a recusal would collapse the commission. So you then say to me, but Chair, if my client has got good grounds to complain that you may be biased, that he fears that you may have made up your mind on certain issues, what happens? It may be that the answer in circumstances such as this is this one, and one would accept that it might not be the best answer. It may well be, and you must just indicate what your submissions are, that in a situation such as this, you are expected as the aggrieved witness to complain later in a review application. Because if you complain later in a review application, maybe if you are successful, the court can set aside the findings that relate to you. If nobody else has complained, the other findings stand. I'm just thinking aloud, and I would like us to look at it. I know you have thought about the issue.
I have.
And that's why I want to benefit from your submissions.
Let me start with the last one that I may review later, for instance, that option. The reason I wouldn't accept that option, not me, I'm saying it wouldn't be acceptable in a legal process like this, is that you making your problem mine, in the sense that because there's a conundrum, my grounds to come before you must be regarded as incompetent simply to make things convenient for you. I don't think that would be the best way to look at it, but it's an option available. But it doesn't, because it won't deal with the problem. And I have no desire that this commission be collapsed, because it's very important. The other thing, Chair, what you are asking me now is truly what I've been trying to say to judges to no avail. There is something wrong with how this thing was established. It was not thought through. It was politically motivated in the thinking. And the challenges you and me face now are challenges caused by the fact that those who thought about this thought about sinking Mr. Zuma and nothing else. And I think if we get those out of the way, one of the things to be done for a process like this, like we would in a court, if we are responsible, is to say, maybe in some respects, Chair, I'm correct in my grounds. And maybe in some respects, I'm not so correct. Could we collapse this commission simply because it's a draw between you and me? And maybe let me call it the third way. Maybe the third way is to look at, because this is not a court, you can craft things to save this as we want, is what can we do to ensure that Mr. Zuma not accounts, because it's wrong to say a commission is a place of accountability. Professors say this out there, they've never been inside a court. Basically, it's not a place of accountability, but it's a place of explaining to the investigator, that is you. And if we create an environment in which, and we can talk about this, I can talk to my client, what is the best way of doing this in such a way that we are responsible in the national interest, not thinking politically? And I think, may I make this, because Chair, we never did, we've been accused. I heard you say we didn't file things. Can I tell you, Chair, that we were on page 200 of the submissions to you when we hit COVID, lawyers were changed and situations. So basically, we're not here to disrupt this place. We were willing to, we can produce 500 pages for you of his perspective, but we had to place before you the fact that we believe that in some of your comments and the environment that we think are politically driven, not by you, but other people, you create an environment where politics contaminates a legal process. And so if there's a way of doing, and you will craft it, you are good at this, you are better than me at this, at crafting what alternative, just and equitable way forward can be created that Mr. Zuma can cope with if he's right on his grounds. Of course, if he's wrong on his grounds, he'll blow us. So I think that relief B, Chair, tries to deal with this problem that was always going to arise when a commission is created for the purposes it was created. And so I put it here to this commission that it's a discussion. I've raised it with Mr. Pretorius, I've raised a bit with you on remedy, that let us look, none of us are perfect in this process. And so if we look at it that way, there may be a possibility of creating an environment in which submissions can be made if you hit that. But if I'm right on my grounds, on all of my grounds, of course I would like 2-0.
Yeah.
Win. But Chair, relief number 2 is truly for that, but it's not because the first one is incompetent.
Yes,
and it can't be incompetent because you have a conundrum. There's got to be another reason why the relief is incompetent, rather than to say, I don't know what to do.
Yes, yes.
Thank you, Chair.
Okay, no, that's all right. So maybe let me hear Mr. Pretorius, and it may well be that after I've had everybody, there might be a need for a discussion, irrespective of what would happen with the application.
Chair, yes.
Yes.
Two discussions may happen, Chair. As I said, I really need to take instructions about your earlier statement. And all of that. Probably tomorrow I will know, but I'll try not to waste any time. And then there may be a discussion about what relief gets us out of here as lawyers. Because we here now, we don't know what political people were thinking when they created this, but we here now, we've got to give this process the integrity it deserves without disrupting it.
Okay, thank you, Mr. Skakane.
Thank you,
Mr. Pretorius.
Thank you, Chair.
Yes.
Firstly, In response to the discussion that has now taken place, I'd obviously like to think about it and
Yes.
prepare an answer for you. But
Yeah.
our initial view is clear, Chair, that if there are grounds for your recusal, you must recuse yourself. There's no halfway in these circumstances where you can negotiate how to proceed with a particular witness, despite the fact that that witness has proved or shown that you are guilty of such bias as to warrant recusal. I'm afraid in that sense, if you are not, however, guilty of bias, then there may be room for dealing from a practical point of view, but we would need to think very carefully about treating a witness differently from another witness simply because they might be implicated or have fears about what your final findings might be. So let me think about that and we will come back to you, Chair. Chair, I'm afraid there's another matter that I must deal with, and that is the reply that was served on us this morning.
Sorry, Mr. Pretorius. I'm not sure, not completely sure that you are right, and Mr. Skakana is also right, when you say if a witness has shown that in this case there is a reasonable apprehension of bias, I should recuse myself. That it always follows. It can't be otherwise. The reason why I'm raising that is that we all know that there are circumstances where somebody, a judge who is disqualified from sitting, is allowed to sit because there is no other one who won't be disqualified to sit, the doctrine of necessity.
Yes, Chair.
So I just want to raise that because I don't want you or Mr. Skakane to necessarily think that I accept the proposition that if we reach a point where it was to be said that there are reasonable grounds, it seems to me on the face of it, and now I'm talking principle, seems to me that you may well have a case where you say, well, you have to sit conflicted as you are if you're talking about conflict, and you just have to do your best to be fair. I mean, we know cases where judges hear cases dealing with legislation, dealing with their own salaries, where they are all conflicted because this legislation is about their benefits. But there is nobody else. Whoever hears the case has to be a judge. So they have to do the best they can to be fair and to disregard their own interests and give judgment.
Chair, we're not here dealing with a conflict of interests. We're dealing with a notional situation where it has been shown that you are guilty of bias in relation to central issues, Chair. Let me put it this way, subject to the doctrine of necessity, and we will address you on the doctrine of necessity because it's part of our approach and it's in our heads of argument. That's a separate issue. But certainly the solution cannot be, given the principles that apply, it cannot be that you can then negotiate with a particular witness in a particular situation.
Leave out negotiate. Leave out negotiate.
Well, you don't negotiate, but that's the invitation. The invitation, Chair, is let's talk about a different solution other than your recusal, on the basis that you are guilty of bias in respect of that particular witness. For us, we have difficulty with that proposition, but we will deal with it in due course.
Okay, no, that's
because there is not one person with an interest in the proceedings that are before you.
Of course.
There are hundreds, and there are thousands, and any one of them might come and say, but you were conflicted, you proceeded, and you treated that witness with some special dispensation, notwithstanding that you accepted that you were guilty of bias in respect of him. It raises all sorts of problems for a later review, which you've been told, Chair, is coming. In any event, Chair, may I move on? We will address you properly on that.
Yes.
And we don't at all take issue with the principle of necessity, that even though you may be conflicted, but that's a matter of general application involving all, not necessarily one witness who complains of bias. Chair, we were served with a replying affidavit this morning. My learned friend said we don't have to worry about it, but I'm afraid unless it's withdrawn, we do have to worry about it, because in it, the applicant makes allegations, firstly, that the secretary is not authorized to depose to the affidavit, and the legal team is not authorized to intervene in this matter. So that there are two allegations. One, that, and if I may refer you, do you have it before you, Chair?
Yes, I do.
If you go to paragraph 14, line 4, takes issue with the fact that the legal team is defending this application. It says, the fact that they have installed themselves as my opponents disqualifies them from performing the functions expected of them, leading evidence. Now, whether that is without merit or with merit is something that we can address. The allegation is made in paragraph 15 that the second respondent has no legal standing. Then paragraph 23 complains that the second respondent was assisted by the legal team. Paragraph 28, it's denied that the second respondent, that's the secretary, has any authority whatsoever to depose to the answering affidavit, and he is challenged to provide authority.
But the whole concept of respondent in this application.
Well, the second respondent was cited as a respondent.
Well, both the first respondent and second, I didn't raise this with Mr. Skakana because it didn't occur. But at a practical level, it might not mean anything. You know, my understanding is that if you bring a review application for an application for recusal before the particular presiding officer, the presiding officer is not a respondent. You don't cite them as a respondent. You cite them as a respondent when you go on review to set aside their decision not to recuse themselves. Of course, the secretary, I'm not sure why they would come in.
In essence, if I may go on to paragraph 82, it says that neither the second respondent has no basis or authority to respond to the recusal application. And then paragraph 89, it is neither for the second respondent nor the legal team to respond to the recusal application. Chair, both, as a matter of fact, both the secretary and the legal team have been given instructions by yourself to deal with the matter in the way it is being dealt, and perhaps that should be placed on record. That may deal with the situation. My fear is that if the situation is not dealt with, and you then rely on statements made without authority in the answering affidavit, and you rely on submissions placed before you by the legal team, then there may be a problem if it turns out that their status to deal with the matter before you is not clarified. So I raise the matter so that it can therefore be clarified, either by a statement by yourself that you direct us to act as we have done, as you have already done as a matter of fact, and clarify the matter, or Mr. Sikakani, who says that we needn't have worried about the affidavit can just withdraw the allegations in the affidavit and we can proceed. But I do think the matter needs attention.
Yes.
I don't want it to be brought up at a later stage,
Yes.
not having been dealt with.
Yes, but I think proceed, and Mr. Skakani will still come back and reply, so he can indicate what his position is.
Well, Chair, then do we have your assurance, both the Secretary, so I can rely on the answering affidavit, and the legal team that we are acting under your direction?
Yes, you are.
Thank you, Chair. Chair, having listened very carefully to my learned friend, whose submissions before you ranged from detailed submissions of fact in reference to the record through to allegations of political conspiracies and the like. Fortunately, our approach is that the law will provide an answer. Fortunately, in situations like these, however contested and by whatever extreme views they may be contested on either side, the law does provide an answer, and we will deal with it by reference to legal principles and facts. At the outset, Chair, listening to my learned friend in his address, it was difficult really to draw the line between what the case being brought before you for recusal was and what the case was not. First, it is clear that, and it's necessary to draw that line, because I think in attempting to draw that line and to understand where the case of the applicant lies in respect to that line, there may be an answer to this application. Firstly, it is clear that there's no allegation of actual bias. As I understood my learned friend, he didn't say as a matter of fact you were biased. He didn't doubt, the applicant does not doubt your integrity. On the contrary, Chair, he insists that the recusal application is brought precisely because he believes you as Chair have the capacity and integrity to hear him out, to hear contrary arguments, and to come to a fair decision. In other words, you have, on the version of the applicant, the ability to be persuaded by argument, by facts put before you, notwithstanding what it might be said your views have been as expressed on the record. Secondly, Chair, and crucially, it's not being alleged that at the end of the day, the chairperson will not be open to persuasion. That's not part of the case. It's not being alleged that you are not open-minded in your approach to the evidence, and you may not be persuaded in good faith to come to a particular conclusion one way or another. In fact, as we understand the argument, that claim has been disavowed. It was unequivocally stated in my learned friend's address that there's no allegation that you've prejudged the matter. On the contrary, as I understand the address, you have been reassured that the applicant has no doubt that you are able to be even-handed and impartial in your assessment of the evidence. The problem is, says the applicant, from what I have seen and heard, I have an apprehension that I will not be treated fairly, and I have an apprehension that my views will be rejected and other views will be accepted in their stead. And that's something different, Chair. That series of submissions and concessions, as a matter of law, takes the case below the bar for a recusal application, because that set of allegations doesn't pass the test. The apprehension of adverse findings, the reaction to comments on the record is not relevant in the assessment of bias, Chair. The test is not what you have said. The test is, has or will your conduct show that you cannot bring an impartial mind to bear on the evidence. That is the test. In other words, before you will be able to recuse yourself, Chair, you must be satisfied that you cannot, and it has been shown that you cannot, and it has been alleged that you cannot bring an impartial mind to bear on all the evidence once you have assessed all the evidence. It's not enough to say, for an applicant to say, in my position as a victim of a conspiracy, I fear. That's not enough. And I'll come to the detail of that in due course. So whether a reasonable person might apprehend that you might make adverse findings, given what you've said on the record, doesn't pass the test. So, Chair, the test which has been stated in the authorities is clear. It's will you or will you not bring an impartial mind to bear, a mind open to persuasion by the evidence? Ultimately, Chair, when you've heard the evidence, all the versions, including the versions of the former president, that's not been alleged on the papers, nor do I understand it as having been alleged in argument. So, in the Sakawa case, upon which my learned friend relied, Chair, it was said by the Constitutional Court, absolute neutrality is something of a chimera in the judicial context. This is because judges are human. They are unavoidably the product of their life experiences, and the perspective thus derived inevitably and distinctively informs each judge's performance of his or her judicial duties. But colourless neutrality, which is the standard that's been demanded of you, Chair, stands in contrast to judicial impartiality, which is the test. So, impartiality, importantly, is that quality of open-mindedness, open-minded readiness to persuasion, without unfitting adherence to either party or to the judge's own predilections, preconceptions, and personal views. Impartiality thus requires that judges will be able to disabuse their minds of any irrelevant personal beliefs or dispositions. Again, not alleged. Again, certainly not shown on the papers, and as I understand my learned friend's argument, not put before you. So the claim before you, Chair, is not that the chairperson's mind is made up and not open to persuasion. It's not been said to you, Chair, that what you have said is not open to being persuaded that you can change your mind. If that is the case, the test for recusal is not met. In that case, there's no ground for the reasonable apprehension of bias, but merely an apprehension by the applicant that adverse findings may be made against him. We'll deal with the detail in relation to the tests and where the bar is, and if the case put forward before you actually reaches that bar or not. Chair, you have before you our written submissions, but before going to them...
Well, I'm not aware that I do have. Are they here?
Well, I'm just told you don't have, Chair. I presume that you would have been given, like everybody else has been given.
Did I have Mr. Skakane's ones as well? Because I saw him reading from a notebook. I assumed he didn't have any, but I don't know. Mr. Skakane, did you have them?
Chair, I'm so sorry. We do. Okay, I will leave a copy for the chair.
Okay, thank you. Thank you. Okay. Yes, Mr. Pretorius.
Thank you, Chair. In the first section of those heads of argument, we summarize what the contentions of the legal team are in this matter. The first point is that the burden rests on the applicant to show bias or a reasonable apprehension of bias. It is in law, as my learned friend has conceded, a heavy burden. Secondly, Chair, the test for bias is objective. It is not what the applicant fears. It is not what the applicant thinks. It is what a reasonable observer would reasonably conclude. Two hurdles to overcome in relation to reasonability.
I think Sarfo says reasonable, objective, and informed.
On the correct facts, yes.
Yeah, on the correct
So
facts.
it's a reasonable observer making a reasonable conclusion, looking at the correct facts. It is not based on conjecture, conspiracy theories, and the like. It's based on correct facts, and it's based on reasonable observation, and it's based on reasonable conclusions made by that reasonable observer from those facts. Chair, as far as the relationship between the applicant and the chair is concerned, again, it is not entirely clear what the case has, but practically speaking, any reliance on that ground seems to have been disavowed, notwithstanding the claim in paragraph 15.1 that you should not have accepted the position as chair. It seems that the applicant has confined his recordal to the historical, professional, and personal relationship between yourself and the applicant. There is no allegation to link those circumstances to bias. Nowhere is it said.
I may have misunderstood Mrs. Kakane. I got the impression that he was not relying on that, but maybe he was. Maybe you should address it in case.
Well, Chair, I don't intend to go into any detail.
Okay.
Simply to point out that there's no allegation that links any relationship, professional or personal, to any allegation of bias. There's nothing that says, because you know the former president, therefore you will be biased for whatever reason, enmity and the like. It's just an allegation in the air. Ultimately, Chair, the applicant relies on the record of proceedings of the Commission to date. Firstly, he complains about the selection of witnesses and says this shows bias. In oral submissions before you, the allegation seems to have changed somewhat into the order of witnesses, because I think, having read the answering papers, it must be conceded that having called 257 witnesses, it could not possibly be said that all those witnesses have been called according to a predetermined plan or project, Chair. But what is worth noting is that amongst those 257 witnesses that have been called is the son of the former president, Duduzane Zuma, Ms. Dudu Myeni, and others who clearly do not fall into the category of witnesses that has been put before you as being a category of witnesses, and we don't admit that for a second, Chair. But as we will address you, Chair, the selection of witnesses in the order, because that appears to be the complaint now, that they were called, is logically explicable by the mandate that you were given. You were told, Chair, to investigate the allegations called as relevant in the Public Protector's report. You were told to use the Public Protector's report as your starting point, and you did that. Having heard those allegations, the scope of the inquiry then inevitably widened, and very, very early on, in 2018, you approached the former president for a version in respect of the evidence that had begun to be led. Without explanation, there has been no response to that. Chair, then the applicant relies on the exchanges between yourself and the witnesses during the course of hearings of the Commission. and various selected passages are relied on. We will deal with some of them. The applicant's assertion reveals two aspects, however. First, we submit to you that there's a lack of appreciation of the duties of the chair in an inquisitorial setting. It's your job, Chair, not the job of the legal team, to interrogate the witnesses, to put versions to them, to make sure you understand what their version is, and to highlight what issues of concern you have, not only for that witness, but for other people observing the proceedings who might or might not be implicated. If you did not do so, Chair, you would be failing in your duties as chair of an inquisitorial proceeding. Secondly, Chair, the selection of passages shows clearly a misreading or misunderstanding of the very passages relied on, and we'll go there to show that. Ultimately, there is nothing in the record that remotely approaches bias or a reasonable apprehension of bias. Put differently, Chair, if the applicant hears the proceedings or reads the record and concludes that adverse findings might at some future date be made against him, that's no ground for recusal. And then there's no merit in the remaining grounds, some of which weren't advanced in argument, press statements, matters related to the medical condition and the like, and we will deal with matters related to the medical condition and so-called press statements or press conferences, which didn't happen. Then, Chair, the applicant also appears to suggest that he's somehow been dealt harshly or unfairly because this commission is insistent on him appearing to testify. Again, Chair, it's important for all to understand that this is not an adversarial process, such as a criminal trial or a civil trial, where if a party remains silent, the other party wins, or the party remaining silent might face a conviction if it's a criminal trial. This is different. This is a commission of inquiry. Here, the commission must deal comprehensively with its mandate and its terms of reference as an inquisitorial body. In short, Mr. Zuma must be heard, and his version must be considered. Why this should constitute bias, we fail to understand, Chair. If one looks at page 83, paragraph 83 rather, Chair, of the answering affidavit,
that's different from, that page number is different from the paginated number.
Yes, Chair. The Commission paginated the papers, so my learned friend, and although they got an electronic copy, we have, for convenience, both been referring to paragraphs rather than pages.
Okay.
So if I may follow that.
Okay.
Where it said the fundamental basis of the application...
I'm sorry, I'm trying to locate the answering affidavit.
Okay,
Is it in the red file?
Yes, it will be in the red file at the back.
After what, which divider?
After the first divider, I would imagine. And it's at page red 78, Chair, if that helps. But it's paragraph 83. Perhaps I'll refer to both.
Are you able to give me the paginated number, the red numbers?
Yes, 78, Chair.
78. I thought you said answering affidavit. 78 is the applicant's founding affidavit. So I was looking for a wrong.
Sorry, I am talking about the answering affidavit, Chair.
Yeah.
Bear with me a
Okay,
moment,
I've
please.
got it.
So if I may just refer you to the answering affidavit. I gave you the incorrect reference, my apologies. What is important, Chair, about the necessity to...
What's the right page or paragraph?
Page 665, Chair.
The red numbers.
Red number 665.
No, Mr. Pretorius, I think your team didn't put in the answering affidavit here. I've got 646 here, 647, and then the next is 697. There's something missing. I read it last night, so...
Yes, Chair, the simple point,
But
it's
you can
been
read
raised
it.
before and you're familiar with the
yeah,
point.
I'm familiar. You can read it.
It's not sufficient for the applicant to say, I've seen several Rule 33 notices. I have elected not to respond to those notices because he says he's not implicated by them. He doesn't have to answer, which is quite a different proposition to the proposition that we now hear about those witnesses who, quite apart from conspiring to harm the former president, have given what is in essence a set of false submissions or evidence. But be that contradiction is there for the record. I mean, either they implicate the former president or they don't. If they implicate him, as appears to be the very basis of the recusal application, your comments on that evidence, then they should have been dealt with through applications for cross-examination and to put the version. At least that opportunity was open to the former president. He could have done so. He elected not to do so. But where the former president doesn't have an election in relation to evidence is when he's summoned to do so, either in terms of Regulation 10.6 or in response to a summons. There is no question of an election. And your reason for calling the former president is manifest. And it's necessitated by your mandate, Chair. You have to hear his version. It is necessary for you properly to complete your work. There's no bias in that approach, Chair. You are obliged, with respect, to do everything within your power, lawfully within your power, to compel the appearance of the former president and to hear his evidence. Chair, if I may turn then to the written submissions. And go immediately to the legal principles, which I've adverted to in the introduction. My learned friend has relied upon the South African Rugby Football Union case, which is a binding and clearly applicable set of principles. The test is highlighted in paragraph 14. The question is whether a reasonable, objective, and informed person would, on the correct facts, I'm sorry, Chair, do you have it? Paragraph 14.
Yes, I've got it, yeah.
The question is whether a reasonable, objective, and informed person would, on the correct facts, apprehend that the judge has or will not bring an impartial mind to bear on the adjudication of the case. That is, a mind open to persuasion by the evidence and the submissions of counsel. Whatever you say and whatever prima facie views you may hold, not the test. The test is whether at the end of the day you are still capable of being persuaded and you have an open mind in that regard. That test is established against the background of the presumption. We deal with that in paragraph 15, the Irvin and Johnson case, Sakawa and Irvin and Johnson. Again, my learned friend relied upon that, a decision of the Constitutional Court. The first point is that in considering an application for recusal, the court as a starting point presumes that judicial officers are impartial in adjudicating complaints. It's that presumption that must now be displaced, firstly by allegations, and secondly by a convincing argument that you, Chair, will not retain an open mind. We don't think that that submission has been made at all. The second is that impartiality does not entail absolute neutrality, but is rather the quality of open-minded readiness to persuasion. So if no case is made out, or you remain unconvinced, Chair, that you cannot be persuaded, you don't have a discretion. You may not recuse yourself, particularly in these circumstances. There is a double requirement of reasonableness. Not only must the person apprehending bias be a reasonable person, but the apprehension itself must be, in the circumstances, reasonable. In other words, it's objective on two grounds. Firstly, objectively speaking, there must be an apprehension of bias, not subjectively speaking, not based on, and we will show, ironically, subjective bias, but based on objective, correct facts. And secondly, that apprehension must also pass the test of reasonableness. We deal in the next section, Chair, with the presumption of impartiality. And in paragraph 19.2 of the heads, we say that that presumption is not easily dislodged. What the cases say is that it requires cogent and convincing evidence for that presumption to be rebutted. Then we make the point in paragraph 21, Chair, that impartiality does not entail absolute neutrality. Impartiality does not require absolute neutrality, but rather an open-minded readiness to persuasion. So, Chair, a judge can have views. A judge can express those views. That's not the test. As long as that judge is capable of being persuaded to a contrary view or to his own view, that passes the test and defeats any reliance on bias or presumed bias. So the Constitutional Court in Sakawa emphasized colorless neutrality stands in contrast to judicial impartiality. Impartiality is that quality of open-minded readiness to persuasion. Impartiality requires, in short, a mind open to persuasion by the evidence and submissions of counsel. And what the extracts of the record show, Chair, is precisely that. You raise a concern, you raise your interpretation on the evidence, you might even say, I might rely on this evidence, or I might rely on the country view, what do you say? And this is where your role, Chair, as an inquisitor comes in. It's your obligation not to remain silent. You are not an umpire who says out or not out. That's not your job. Your job, Chair, is to raise, you are the investigator, not the legal team. The legal team is there to assist you. It's your job, if I may say, without presumption, Chair, but this is for the purposes of argument, it's not a lecture. You may say, Chair, that I should remain silent. I must just hear the opposing parties, and there are no opposing parties in this matter, and I must decide who is right and who is wrong. That is not what an inquiry is about. It is your job, Chair, with respect, to investigate, to ask questions, to interrogate, to test versions, to put contrary versions, to raise your concerns, and you've done no more than that. Chair, then in the next section we deal with the double requirement of reasonableness, and we talk about the test for recusal being objective in two respects. It's the reasonable observer making a reasonable conclusion on all the correct facts. So, mere apprehensiveness on the part of a litigant that a judge will be biased, even a strongly and honestly felt anxiety, is not enough. And what you have before you, Chair, and we'll show that by reference to the papers, is a hugely subjective assessment of what has occurred in this commission. So what the law does, it imposes on the fears and apprehensions of an individual litigant in an adversarial context, or any witness in this context, it imposes a normative assessment. It says your fear, your apprehension, must be tested against two objective requirements of reasonableness based on the facts. It must be a reasonable person, not you, and it must be a reasonable assessment. Chair, then we go to the application of this test in the context of the Commission. And we make the point in paragraph 29, to which I've alluded, that the Commission is a judicial commission. It should not be confused with adversarial court proceedings. This is not a court of law, that's stating the obvious, Chair. It is important to understand, again, perhaps so that this argument and what your duties are can be understood in the public eye, Chair. Here, there is no dispute brought before you by a party in an adverse relationship with another party. There is no case presented to you which one party seeks to prove and the other party seeks to contradict. So your job, Chair, in that situation might be to sit back and listen to the parties, to weigh up the evidence led and the case put before you by either party, and to determine who is right or wrong. It's not the situation here at all. Your situation, Chair, is as the main inquisitor, and in fact the only inquisitor, to dig deep into the versions of the parties and to make sure that the public out there know what the concerns are that need to be addressed in this commission. So, Chair, when a party remains silent in a civil trial, the other side might win. When a party remains silent in a criminal trial, a conviction might follow. You have been invited by the former President, Chair, to make whatever findings you determine in the face of a failure to answer the versions put implicating the former President. But that invitation is not good enough. The version must be put before you can say, I've done my job comprehensively. It would be entirely second prize for you to accept evidence in the absence of counter-evidence from the very person who claims that he is at the center of the allegations. So, Chair, your job would then be in the inquisitorial process to uncover the truth, having heard all the versions, so the public can be satisfied that the recommendations you make to the President, which are not binding, by the way, but the recommendations ultimately that you make to the President can restore some public confidence in the institutions and processes of government as a whole. So, Chair, according to the authorities, the Commission, and I'm referring to the Corruption Watch arms procurement case where the court laid down quite extensively the duties of a commission of inquiry. The Commission has a duty to squarely test the veracity of the evidence before it, rather than asking only peripheral questions. You cannot remain silent, as enjoined in argument, Chair. It must subject the account of implicated persons to rigorous scrutiny in an attempt to arrive at an accurate set of findings. There's not one, but there are hundreds of examples of that happening in this Commission. The same applies to witnesses who accuse others. Their version must be tested. If, Chair, you are concerned that a witness before you has given clear and convincing evidence, there is nothing wrong. In fact, it's probably your duty to say so as a matter of concern for others who might be implicated by those witnesses, so they are alerted to the fact that they need to come and give contradictory evidence. So, Chair, when the Chairperson places on record his understanding of the import of the evidence, both for the witness and for implicated or concerned parties, he's acting entirely appropriately, particularly in an inquisitorial context. And it may well go further, Chair. You may have an obligation to do so, which, if you fail, may lead to questions being asked about the propriety of the Commission's proceedings. So, Chair, although the test for recusal remains the same, whether this is an adversarial trial or a commission of inquiry, the application of the test must, according to the authorities, take place or take account of the specific institutional setting of a chairperson in a commission, which is different from that of a judge in court. Chair, I'm not going to deal with the allegations in relation to the relationship between the parties. I accept what my learned friend says about the purpose for which those allegations are made in the founding affidavit. But, Chair, from paragraphs 36 to paragraph 47, the issues are dealt with in detail. And of course, it bears mention that all the circumstances relating to the personal relationship were in place long before you were appointed to your current position as Deputy Chief Justice, or even before you were appointed to the bench, Chair. Then, Chair, the nub of the complaint giving rise to the claim for your recusal is dealt with in paragraph 48 and following. The applicant says, first, the selection of the Commission's witnesses exhibits bias. And I must correct that because, from what my learned friend says, gives rise to an apprehension of bias, and it's not just the selection, or not the selection per se, but the order in which the witnesses were called. Secondly, the Commission has allegedly ignored Mr. Zuma's testimony. Thirdly, the Chairperson has made prejudicial comments against Mr. Zuma. Fourthly, Mr. Zuma was treated unfairly during his appearance before the Commission. Fifthly, the Chairperson doubted Mr. Zuma's bona fides regarding his ill health. And sixthly, the Chairperson's press statements concerning the applicant are justified and exhibit bias. That's a very rough and broad summary, but included in paragraph 48.3 of the comments raised in the founding affidavit. And our submission is that these grounds for recusal are simply without merit. Even if taken cumulatively, no reasonable person would apprehend bias when observing the conduct and record of the Commission. We deal in paragraph 50, Chair, under the next heading with the issue of selection of witnesses. The allegation is apparently that the Commission has exhibited bias or raised an apprehension of bias in its selection of witnesses. And that was qualified this morning to the extent that the allegation appears to be that the order in which these witnesses were called raises an apprehension of bias. And of course, that concession of necessity had to be made. It was pointed out in the answering affidavit that 257, not 9, witnesses have been called. And amongst those witnesses are those who could hardly have been said to have held the type of view that the applicant and his legal representatives pin on the witnesses who have given evidence in the category complained of. Chair, the first answer to that proposition is that you have done no more than execute your mandate. You were given the report of the public protector. You were told to investigate the allegations of the witnesses who gave evidence before the public protector, to use the report as your starting point. And you did no more than hear the witnesses many of the witnesses who fell into that category, and then began to explore the evidence arising. Secondly, Chair, you're dealing with allegations of state capture, corruption, and fraud. It's necessary for you, with respect, Chair, as an inquisitor, to understand those allegations. You must hear what those allegations are about. You can't make any presumptions as to what those allegations are about. You can't rely on external sources, press reports, what people may say out there. You need to hear firsthand, and you've done that, Chair. The logic behind the Commission's work is also clear. Witnesses who give evidence before the Commission were initially at least identified by the investigators in consultation with the legal team, and finally determined by yourself. You give directions as to who should be called to testify, and witnesses who come before the Commission are those that are called upon to testify after investigation, and those who voluntarily come forward to testify. Ironically, the former president hasn't offered himself to give evidence at any stage, let alone at the beginning stages of the inquiry. In paragraph 53, we point out that amongst the 257 witnesses, excluding Mr. Zuma, that have presented evidence before the Commission, include Mr. Duduzane Zuma. There's no complaint that he was unfairly treated, at least that we know of. Ms. Dudumieni, Ms. Nomvulu Mokonyane, Mr. Mosebenzi Zwane, Mr. Des van Rooyen, Mr. Richard Beloy. That's a preliminary list. There are many others who cannot at all be accused on whatever conspiratorial basis of belonging to a category of witnesses designed to further the aims of a political project. Secondly, Chair, what appears to have been ignored are the repeated calls made by the Chair of the Commission to the public for people to come forward and give evidence. You haven't said, those that believe in this political project and conspiracy, please come forward. You've made it quite clear that anybody who has any information, from the highest office to the most humble office, should come forward to assist. You have said that not once, but many, many times. And you've expressed on occasion your disappointment that there has appeared to be a reluctance on the part of some to come forward. Chair, in the following paragraphs at page 15 and following, we deal with the specific context which must be notified in accordance with the authorities, or must be noted in accordance with the authorities, that the person against whom bias is alleged must be judged in the context within which that person acts. In other words, in this case, in inquisitorial proceedings. And the authorities we quote at paragraph 56 and following. In short, Chair, as chairperson, you're obliged to be more inquiring than a judge would be in an adversarial setting. So, Chair, in paragraph 58, we refer to the Standard Bank case, a judgment of the Supreme Court of Appeal, which says that a supine approach, in other words, the silent umpire approach towards litigation by judicial officers, is not justifiable either in terms of the fair trial requirement or in the context of resources. Chair, in paragraph 59, the Burnett and Absa Bank case, the following was said by the Constitutional Court. Judicial officers will put questions to counsel or their legal representatives based on those impressions. In other words, impressions that you may form or you may have been requested to form, and thereby provide litigants with the opportunity to rebut any correct impression formed. This does not give rise to a reasonable apprehension of bias. Simply put, Chair, if you gain an impression, or if you are asked to accept an impression and you express that, that does not mean that there is or can be a reasonable apprehension of bias. So it is not bias for a judge to say what he has been asked to think. It's not bias for a judge to say what in the course of a trial he is thinking. It is only bias when he shows he can never change his mind and he's not open to persuasion. But, Chair, the very reason you raise those issues is to invite persuasion and contrary views. And that's clear from the record. And that really is the crux of the case, Chair, because that bar that hurdle hasn't been passed. So, Chair, we expand on that notion of a judge in inquisitorial legal systems or in an inquiry of this nature. In an inquisitorial legal system, and this is an inquisitorial process, Chair, the judge takes the lead. Counsel, legal representatives are there to assist and ask questions later, not in the beginning. So, Chair, it is perhaps surprising that the applicant can rely on the passages that have been relied upon in the finding affidavit to show bias, rather than a truth-seeking exercise, and at sometimes a forceful truth-seeking exercise where you raised issues and you insisted on answers. So the active questioning of witnesses, the testing of propositions, the provisional acceptance of propositions is part of your duties with respect. Chair, we have searched in vain for any display of hostility as alleged towards Mr. Zuma in any public comment that you might have made. There is no unkind public comment that you have made. And in any event, it would have to be shown that those comments, whatever they were rendered you incapable of maintaining an impartial mind, and that's not part of the allegations that you have to deal with. So, Chair, it's difficult not to conclude that the real reason the applicant is before you in this application is that he has an apprehension that there might be findings against him. That is dealt with in the Sartfu case, Chair, in paragraph 71 of our heads, where it is said, "It needs to be said loudly and clearly that the ground for disqualification is a reasonable apprehension that the judicial officer will not decide the case impartially or without prejudice, rather than that he will decide the case adversely to one party." There's a fear that things are not going too well, that the evidence is mounting, that evidence seems to be convincing. Even if you say that, Chair, that's not enough. It's the absent impartial or prejudice absent approach to all that evidence. So the test for recusal, according to Burnett in the Constitutional Court, does not permit a disgruntled litigant to successfully complain of bias simply because the judicial officer has ruled against him or her. Still less, said something in relation to evidence that might not sit well with the particular complainant concerned. Chair, you have made no findings in relation to what some may call a political project, nor have you expressed any view in that regard. You have made no findings in relation to a conspiracy. We can assure the applicant, although I don't want to go too far into what the investigators do because the regulations preclude that following on the evidence of the former president at the last hearing in July of last year, extensive steps were taken by the investigators to take statements in regard to the evidence given by the former president on the first day. Not only that, there has been a response from certain witnesses implicated by that evidence who have come forward and give evidence. That is a matter in process. I don't want to go into too much detail, but Chair, the matter has been dealt with and is being dealt with, as we must. Secondly, Chair, the applicant has not been singled out by the Commission for any special treatment. If anything, he may complain that he has been given favourable treatment and treated gently. There is no doubt that, as my learned friend concedes, that the former president is central to the work of this Commission and any potential findings. And that is why, Chair, you want to hear his evidence. And that is why you've called for that evidence, whether in written or verbal form, throughout, persistently, and from the latter part of 2018. We set out in paragraph 76.1 the reasons why Mr. Zuma's evidence is so important to this Commission. We don't need to repeat them. They've been stated many times.
I wanted to say something, Mr. Pretorius, but as I say, it's more for Mr. Skakane to hear so that when he comes back, when he replies, he has thought about it, if he needs to think about it, and he can deal with it. Well, Mrs. Kakane has said that the case is not that of bias. As such, it's apprehension of bias. But, of course, I think some correspondence, and I don't know whether the affidavit as well, but at least some correspondence suggested, as I read it at least, bias. And I was concerned, and of course there was some correspondence thing that was talking about predetermined outcome and things like that. And I was thinking, you know, if I am biased against a particular witness, and that witness has been given 3 notices and has elected not to challenge the evidence of witnesses who implicate or may be said to implicate him. If I'm biased against that witness, seems to me the easiest way would be not to insist that that witness should come, but to say, okay, I'll just take the evidence, all the evidence against that witness, because, of course, my findings when he has not brought his evidence to put his side of the story is just going to be based on that. But when you want to hear all sides, one wants to weigh everything so that you don't make findings based on just one side of witnesses. I would have thought that it would be seen as somebody who really wants to hear all sides before making a finding, rather than say, well, you got a chance to challenge this evidence, you have elected not to challenge, so it's fine, we'll go ahead with the witnesses who have given evidence. So, but based on Mr. Skakane's submissions, I think that may have fallen away, but he might be able to might say something.
Chair, if you were a judge in a trial, you could adopt that attitude. You could say, if in this civil trial the defendant doesn't want to give evidence, as an umpire of the contest that I see playing out before me, I'm entitled to decide. You wouldn't, in ordinary circumstances, be entitled to force a party to give a version before you. I stress in ordinary circumstances. But the approach that you've adopted is not because, with great respect, Chair, you're a nice person or you're a fair person. It's because you have to. In an inquisitorial situation, you have to cajole, compel, do whatever you have to conclude your mandate. Because quite frankly, without all the evidence, the findings that you will make ultimately must be appropriately qualified. And if someone is keen to see this commission work, that person should be knocking at your door persistently to say, I have a version, I have facts, I want to put them completely before you, and I want to deal with all the evidence of this conspiracy against me. And with respect to the former president, the impression being placed before you is that he does seek to cooperate. Well, that's not the history of the facts before you, Chair. And those have been set out in the summons application. They're summarized in paragraph 77, where we are now. There, you asked right at the beginning of the proceedings of the Commission, in relation to the very first witnesses, Mr. Zuma, please give me your written response to the evidence of Ms. Mentor and Mr. Maseko. You have not got that response. You've asked again, please, can I have that response? You have not been favored either with a response or an explanation for the failure to give the response. In July of 2019, an undertaking was made that you would receive a response to the areas of interest document. You were told today that, well, there were COVID difficulties and there were difficulties in relation to attorneys being changed. I'm afraid, Chair, that explanation has never been proffered before you, except today when the former president is facing summons, and it's not good enough.
Of course, COVID-19 happened this year, and the affidavits should have been filed or delivered sometime last year.
Sometime last year, shortly after August of 2019, Chair.
Yes.
There's no reason why that document, no acceptable reason why that document could not have been presented. It does indicate that there is a reluctance to participate in the Commission other than by way of election not to respond in terms of Section 3(4) and the like.
Well, you see, and again, this is something
Regulation 3.
I mention more for Mr. Skakane than for you. One gets concerned if there's an undertaking made to say, we will file affidavits by whatever agreed date, and then not only are the affidavits not filed, but no attempt is made to show courtesy of an explanation to say we have some difficulties. These are our difficulties. Can you accommodate us? Or ask for an extension of time. One gets more concerned when one deals with that situation.
Yes, Chair. In paragraph 77, we go on to say that Regulation 10(6) directives have been issued. Not once, but twice at least, repeatedly issued. No response, no explanation for any failure to respond. And the answer to that conduct, Chair, may lie in the propositions put to you this morning, that in fact the former President is of the belief that this State Capture Commission is a political project designed to somehow defeat or prejudice in a significant way the former President. That would explain the conduct to date, and that cannot rest comfortably with the notion that full cooperation has been offered, which it hasn't, and is being offered. And one would hope that perhaps after today, full cooperation will be offered. And that's not, with respect to her, the Ms. Duramieni approach, Chair. This Commission needs a full explanation of that approach that says this is a political conspiracy designed to defeat the former President. Chair, I want to refer to two things which indicate that far from being objective, the approach adopted by the former President is itself based on conjecture and bias. If one looks at the founding affidavit, paragraph 41, I don't have the red numbers, Chair, immediately.
Did you say paragraph 41 of the founding affidavit?
Yes, Chair.
I will find it. Yes, I've got it.
Yeah. For the record, read page 30. Chair, the statement is made as follows. It is clear that the Chairperson took a view that I must simply answer the narrative that I dismissed Mr. Nene for nefarious and corrupt objectives related to the so-called nuclear project. Nene is portrayed as one who stood guard against my alleged unrealistic and corrupt ambitions to cause assertion just fails to understand the job that you have to perform. You have a proposition before you which gives an explanation as to why a particular minister was dismissed. You call upon the President to answer that. The President says that's ridiculous. Why call upon me to answer that? The proposition just needs to be stated for it to be understood as fallacious. It's your duty, once again, Chair, whatever you might think, or whatever anybody else might think about that allegation, to call for an answer. And it's the duty of someone who seeks to cooperate in the affairs of the Commission to answer. And so, Chair, it's perhaps ironic that an important witness, that is Mr. Zuma himself, who is potentially able to contradict, confirm, clarify evidence referred to by him in his founding affidavit, has been repeatedly invited and now summoned to give evidence. But there appears to be, and I hope it's only an apparent conclusion that might be drawn, a reluctance to come and do that, Chair. Chair, I'd like to deal with the question you raised earlier with my learned friend about the nature of the relief sought. We deal with that in paragraph 88. In the notice of motion, prayer 1, the prayer is the following: recusing the chairperson from chairing the Commission of Inquiry proceedings relating to the applicant's testimony and directing that lawful steps be taken to find a replacement chairperson to hear the testimony of the applicant. Now, that is unclear, Chair. The second part is clear, that what is required is that a replacement chairperson come and sit here this week and hear the evidence of the applicant. What is to happen to the contradictory evidence given by 33 or 34 witnesses? Who must judge that evidence? Who's going to make findings about credibility? What if the new chair believes that this was a political conspiracy and this whole commission is a political conspiracy, and you find the opposite? The situation on the narrow interpretation that you must recuse yourself for this week to hear this evidence, it's unworkable. But if one goes on to the affidavit, in paragraph 3 of the founding affidavit, the applicant says, the chairperson is required to recuse himself from presiding over those issues that pertain to Mr. Zuma and his family. He says myself and my family in the affidavit. It's incorrectly recorded there in paragraph 88.3. I apologize, Chair. But in essence, he's saying that you must recuse yourself from presiding over all those issues that pertain to Mr. Zuma and his family. That would include Mr. Duduzane Zuma, whose evidence you've already heard, and would include anything related to your several terms of reference in relation to which Mr. Zuma is expressly mentioned as being implicated by the terms of reference, and all the evidence that has been given. Who's going to draw that line between you and your replacement colleague as to what you can do and what someone else can do? In fact, the authorities are quite clear, Chair, that once you've recused, you can't make findings. And it would mean that you can't make findings central to the Commission. It would render your future participation in this Commission entirely nugatory and would mean, in fact, the collapse of the Commission.
Can one ever, in a commission such as this, recuse oneself from hearing the witness, the evidence of a specific witness or certain specific witnesses, but hear the rest of the witnesses?
Chair, I suppose, to think about it for a moment, there may be a situation where there is an issue so separate and discrete from the main issues that the Commission has to deal with, that it could be decided, for example, by a medical expert or by an accountant or by an engineer, and then you would rely on that finding. But ultimately, the responsibility for the findings remains yours.
I guess in that situation...
But not in this case, Chair, quite clearly.
I guess in that situation, if it comes back to you, it's difficult to see somebody else making a finding and you are bound by it. It's different maybe if they make a recommendation and you can then make a finding in regard to such a matter.
I'm sorry, Chair, I was distracted for a moment. Would you mind repeating that?
No, I'm saying it's difficult to see a situation where somebody else, you made an example of some medical expert making a finding and then you are bound by it as chairperson. It's different if they make a recommendation which you can examine, and if you are persuaded it's right, you accept. But there are all kinds of difficulties that might need to be looked at, because in the end, the findings in the context of this commission must be the findings of the judge selected by the Chief Justice. If it's findings made by somebody else, that might be problematic, because the remedial action said these issues must be investigated and decided upon by a judge selected by the Chief Justice and appointed by the President.
Chair,
okay.
The furthest one would go in the context of this commission is that it would perhaps be permissible for you to rely on the opinion of an expert where you feel that you don't have the ability to make the necessary judgment. But the decision as to whether to rely on it or not would remain yours.
Yes, yeah.
It doesn't appear to me that there's any room here for a second chair to deal with all matters relating to Mr. Zuma and his family. Drawing a line between those issues and the remaining issues of the Commission would be impossible.
Yeah, okay.
In fact, the central issue in this Commission, according to the terms of reference, is the issue relating to, or are the issues relating to Mr. Zuma and perhaps his family as well. And then, Chair, between you and your replacement, who would decide what issues relate to Mr. Zuma and his family? And what if there's a disagreement? Who wins, as it were? It's just simply unworkable. One just needs to think through the implications of that proposition to understand that it really is, unfortunately, and I hesitate to say this because it's an extreme conclusion in many contexts, it is an all or nothing position where there can be no compromise. Chair, if I may deal with, I see I do have a little time left.
Yes, okay.
With some of the extracts that were relied upon in the founding affidavit. Chair, if I can take you to the numbering is somewhat problematic at one stage where paragraph numbers are repeated, but if I could take you to paragraph 53.2 on page 32.
Are you talking about the founding affidavit? No, 32. So what document are you talking about?
The founding affidavit, Chair, page 32 of the founding affidavit.
At page 32, I've got paragraphs 46, 47, and 48. I thought
Yes,
you
Chair.
said paragraph 50-something.
Again, I'm not referring to the red numbers. I'm referring to the page numbers. It's at page 26, Chair.
Let's stick to
red number 26.
Let's stick to the red numbers.
Okay, Chair.
Yes, I've got that. Were you referring to paragraph 32? Were you referring to paragraph 32?
No, paragraph 53.2.
53.
Yes, Chair. Again, the numbering is confusing because it's a repeat.
There is no paragraph 53 at page 26. Page
Red
26,
number
red numbers.
Chair. Sorry, 26.
Page 26, red 26 only has
I
paragraphs.
hesitate to say I've been misled. It's my responsibility. It's red number page 37.
Okay, I've got it.
You have it, Chair?
Yeah, paragraph 53.2.
Yes, Chair. There the extract is dealing with an exchange between yourself and Ms. Hogan. And in the second paragraph, when dealing with her evidence about the former president, you say, you put, is there room? You can just answer this question to the best of your ability. Do you think there may be room for any suggestion that maybe your personality and his personality, your respective ways of dealing with issues, were such that the kinds of differences that came up maybe were likely to come up? Or is that something you have not thought about? So in other words, an issue is raised in your mind that maybe this is all down to a difference of opinion, that it doesn't bear the import that the witness, Ms. Hogan, intends, and you raise it as a concern. That doesn't mean to say you believe that, or that you're trying to persuade the witness to say that. On the contrary, you're merely raising it. And then the passage relied over the page, relied upon by my learned friend, the whole passage should be read, because after the underlined portion, there's another portion which says, but having said that, I think that I must say that should not necessarily mean that he, the former president, did not have in mind that the board could do whatever it considered it had a right to do. In other words, if it decided that it would dismiss him, that's Mr. Moroka, it may well be that he was not excluding that. But what he said to you just seemed to say, look, Mr. Moroka will continue as CEO, and then the person might think you were getting at, because he believes that this commission is part of a conspiracy and Ms. Hogan is a proponent of that conspiracy. The test is, at the end of the day, will you be able to assess this evidence impartially, with all the propositions for and all the propositions against that you have put? Complaint is made, Chair, about what you say to witnesses, including Ms. Hogan and Mr. Gordon, thanking them for coming to give evidence and the like. Chair, your approach consistently throughout this commission from beginning to end is to thank witnesses for coming forward, for giving their versions, and in the same breath to encourage other witnesses to come forward. That somehow is an expression of bias, is simply untenable, reasonable apprehension of bias. Then it's also complained that at paragraph 53.6, in dealing with Minister Gordon, you say at the bottom of page 36, okay, that paragraph appears to me, and you must tell me if you understand it different, appears to be an acknowledgement by the ruling party that the leadership structures that it had up to that stage were failing to arrest corruption, and that these other practices that are mentioned there, is that your understanding of the paragraph as well? In other words, the statement of the witness has implications. You point out those implications and you ask the witness for those implications. In no manner can it be said that that is your view in relation to the ruling party, not the former president, the ruling party. That can never be changed. That's not alleged and it's not proved. All that is said is that the applicant reads that and is worried by that statement. That's not the test. Then, Chair, at the bottom of page 37, that same paragraph, you say to Mr. Gordon, I take it that the former president did not articulate his views in regard to the suggestion you made about what process you were thinking should be followed. In other words, what the president did not say is indicative of a conclusion that might be drawn, that he did not confirm that what you said about him is correct. It goes the other way, or it could go the other way. It doesn't matter, Chair. You're exploring. Over the page, Mr. President Zuma, I think, is President Zuma that he may want to put his preferred candidate through the usual process. What I am saying is I take it that he did not articulate to you any views about your suggestion at that time. We know that later on he did not follow that process, or you cannot, and then there was an intervention. And Mr. Gordon then admits, not in an explicit way. In other words, there's no confirmation there that President Zuma wanted to follow course A or course B. Then at the bottom of the page, you ask a question. Would the involvement of the presidency in the appointment or reappointment of members of boards or of SOEs have been a normal thing? Is that a normal thing or not? A witness gives evidence as to that, and then you inquire as to its import. I don't see that that shows that you can never bring an objective mind to bear on that evidence. And then over the page, again with Mr. Gordon, you say to Mr. Gordon, am I missing anything that one could really say did happen that could be said to reflect a breakdown in the relationship between the two of you, other than maybe just differences of opinion on certain issues relating to work? You've raised that issue before in evidence, Chair, where you say, look, is this not explicable or explainable by a difference of opinion that you just didn't get on, that you couldn't work together, and that explains the conflicts that you've spoken about in your evidence? Again, not a decision that that is so, but merely exploring whether it is so. Chair, if I may, one could go on, Chair, but I think that the pattern is clear, that there's no evidence here in any of these extracts that you come close to saying, I've made up my mind and I'm not going to change my mind. Or you exhibit exactly the opposite, if I may say with respect. The propositions you put are generally qualified. So on page 41, you say, my other question is this: if at the end of this process I come to the conclusion that definitely there wasn't state capture, there are certain consequences that follow and certain questions you must ask as a result of that. There's no finding that state capture is a reality in your mind, Chair. And so one can go on, but I would like to just take one step further the proposition that, in fact, the propositions that have been put to you in the papers on behalf of the applicant and in argument by the applicant themselves rest on a preconceived notion and set of ideas and are coloured by that approach. So it's based on the fact that this commission is a political conspiracy designed to undermine the former president and certain of as part of a factional struggle that inform the views that interpret the passages that have been put before you. And I may just take you to one glaring example. Page 46. Well, let's start at 45, paragraph 53.9. I'm referring to the pages at the bottom again, Chair. If you want the other page for the record, I can give it to you.
It's better if we are consistent and use the red ones, the red page. Of course, you can mention both if, I think you said Mr. Zuma's legal team might not have read pagination.
Yes, I'll mention both. It's red number 50.
Okay.
Paginated or typed number 45. That's the answering affidavit numbers. Paragraph 53.9.
Okay.
Now, if there's any preconceived idea, it's expressed in this paragraph. And it's a preconceived notion about your role, Chair, and your vision of matters. 53.9, the deponent to this affidavit says, on 12 August 2020, the chairperson made an attempt at seeming impatient with Gordon. In other words, the accusation is when you were visibly upset with Mr. Gordon on the 12th of August, did so, in no uncertain terms, it is then interpreted as you producing a sham. In other words, lying to the Commission and to the public that you are only pretending because you are so fond of Mr. Gordon and his political position that you weren't impatient or upset with his attitude of not coming to the Commission, which you dealt with at length, but you made an attempt at seeming impatient. Now that's preposterous, Chair. Quite frankly, to accuse you of that indicates, and apart from saying so, what it does indicate, coldly looked at, is that your conduct is being seen through a bias and a misapplication, and it's not an objective, reasonable assessment of the facts, and that's a prime example of that, Chair. And if you go over the page, you will see there that you were quite clear, Chair, that you were not happy with Mr. Gordon's conduct and just deciding not to come to the Commission. And the reasons are well-founded, because the Commission is frustrated that it cannot ensure that people come when they're required to come, and it upsets the calendar, and the limited time that we have is put to the test. One more, Chair, paragraph 54, page 54 to 55. In relation to the evidence given more recently by Mr. Tsotsi, and whether the former president arranged a meeting or whether the meeting was arranged by Ms. Miene. You put it quite clearly there that perhaps the former president wasn't involved in the arrangement of that meeting because he came to that meeting and immediately asked, what is this meeting about? And you looked at the probabilities involved in that and you said this probability points in the direction of the former president not being involved. At least that's as I understand the evidence. There's a host of different examples in these extracts, let alone, Chair, the other 300,000 odd pages that constitute the record. Chair, if you would bear with me a moment.
Okay.
Chair, there's another example that's been brought to my attention by a member of the legal team, where you said in relation to the evidence that was led in the Transnet stream, where you said on day 285 at page 209 of the record, I'm sorry, Mr. Myberg, please don't forget your point that you want to ask. I just want to mention one thing arising from what I said to Mr. Makonazi. You see, Mr. Makonazi is going back to what I said last time. I said Mr. Zuma has denied Ms. Hogan's version and that he said his only choice for the position of Group CEO is Mr. Gama. I don't know what finding I will make in the end, but if Ms. Hogan's version is true, then it seems that there may be room for someone to say Mr. Zuma would have been quite disappointed in the fact that Mr. Gama was dismissed and had been dismissed because that ruled him out of the running for the position of Group CEO. And it may well be that a new minister had a discussion with him and that he might have mentioned that there was this issue of Mr. Gama and he needs to look at it. He might not have said he should be reinstated, but he might have said he should look into it. And maybe that is why he instructed you to review it. An innocent version. Again, it strikes you during the course of evidence that there may be another explanation other than that the witness is contending for. Doesn't have to be your view. You raise it and you ask questions about it, as you must with respect, Chair, as an inquisitor. Then, Chair, finally, if I may say something about commissions and the role of a commission of inquiry. Chair, this commission doesn't give a judgment, which will be a final judgment for or against any person, including the former president. Judges sitting in commissions are instruments of the executive branch of government. They must establish a factual matrix on a particular topic, and they must make recommendations on the basis of facts so found. Neither the findings of fact nor the recommendations bind anybody, least of all the applicant for recusal, whose better remedy, it is suggested, Chair, is a review of the findings made against him. Chair, there is nothing in the papers, and there's nothing with respect to my learned friend in his argument, other than a plea to reconstitute or reorganize the manner in which the former president testifies before the commission. It's a plea ad misericordiam that passes the test for recusal. And Chair, in that circumstance, you have no discretion. Even if you wish to, out of deference to the former president, you cannot recuse yourself, Chair. Thank you.
Thank you, Mr. Pretorius. Mr. Skakane. Maybe I say it's 4 o'clock, maybe we should take a short break. 10 minutes. Yeah, let's, well, earlier on we took a tea break, and maybe because of the numbers of people, it's difficult for everybody to come back on time. Should I make it 20 minutes, or what do you think, Mr. Pretorius and Mrs. Kakan? Guide me.
I think the numbers are on Mr. Sikakani's side.
Chair, I'm going to be very brief. Maybe you want to take hours of a break, so I'll give you 5 minutes, reply, and you go home.
Oh, okay. Then maybe I thought you might
take a break for 24 hours.
Yes, okay, all right. No, then maybe let me hear Mr. Skakane, because I thought it might take long.
I won't.
Okay.
Chair, I have very, very few submissions to make. One is to start by accepting, Chair, as you know, in the affidavit, when we have no way to know that the person has authority. As you know, there is counter questioning of bona fides here. We accept your bona fides that there is that authority. We have no reason not to. And then, Chair, we were doing very well. You and me argued for 3 hours. None of us patronized each other. None of us assumed one of us doesn't know much about something. And I take serious exception to being patronized by Mr. Pretorius. I don't know how many times he said we failed to understand something. We failed to understand. It's not true. I know no less law than he does. It's not failure to understand anything. We agree on the test, and I have a view about the test, and he has his view. And so to say the following things, he says, for instance, we nowhere do we say, and I'm not re-arguing this point, he says, nowhere do they say you won't bring an impartial mind. Chair, we say that in paragraph 6 of the affidavit. I'm not re-arguing the point. I'm just saying, for a man accusing me of making false submissions, that's false.
What paragraph?
Paragraph 6 of the affidavit. We make that point. He says no way. And I think it's him who's making false allegations. And then he says we're peddling conspiracies. It's not true. I have put to you what is in the mind of my client and what concerns him. I have not questioned the legal team about their knowledge. I've not questioned them about anything. I'm putting to you what my client apprehends, and he may differ with me. It's not because I don't understand anything. So that prejudice offends me. And then he says that I have quoted selectively. Chair, that is an accusation of dishonesty on my part. It's not true, Chair. I could not come here with the whole record. We say right at the beginning of the affidavit that we quote for you some of the exchanges. I could not burden you with all the exchanges you've had. So I take serious offense to being patronized in this way, because I was quoting to you. I could go on, and we could differ about which ones are good and which ones are not. So my quoting particular ones was to demonstrate to the chair in our discussion about what I said were issues of perhaps lack of sensitivity on the part of the chair. And I could go on and on. So I was not quoting them selectively at all. There was no dishonesty on my part. And Chair, lastly, perhaps this is how Mr. Pretorius exposes what sits in his head. He says, and Chair, this is not you. You have not said this. I accept all the arguments you made against me. He says sarcastically, maybe Zuma has reasonable apprehension that there may be findings against him. Chair, that is just an insult and unfair, because it questions Mr. Zuma's bona fides for no reason. That's not what he fears. He fears no finding. And so this conspiracy itself is a problem. He has told you, Chair, his fears. And he has told you that he does not fear any finding. But he is told by the evidence leader that that is what he fears. So I want to say, Chair, I've stated to you, and there is no point that I make that I'm going to pull back on. Those arguments are what they are. I understand the test that he thinks I don't understand. And Chair, you have the responsibility to assess it, find against us if you must. I can see he wants to take the Stalingrad approach. He does. I'll let him do it. We'll see who wins. But we must be constructive about this. And it's that attitude, Chair, that I think has made difficult for your commission. It's not you mostly. It's the attitude that I think has a particular slant against Mr. Zuma and doubting us. And I don't even know what the prejudice is of doubting our bona fides and knowledge. It just offends me. Thank you, Chair.
Okay, thank you, Mr. Skakana. We are going to adjourn for the day.